Supreme Court of India Somjeet Mallick vs. State of Jharkhand and others decided on October 14, 2024 INSC 772. Facts of the case: the appellant filed an application under Section 156(3) CRPC alleging that the second and third respondents offered to take appellant's truck trailer number NL01K1250 on a monthly rent of Rs 33,000 exclusive of drivers/helpers' salary. For plying, an agreement was entered into between the appellant and the accused, rent including arrears amounting to Rs 12,49,780 was not paid despite repeated false assurances. Application under Section 156(3) CRPC. The learned CJM directed the police to institute a case and investigate. The High Court deed impugned order quashed the order of cognizance and all further proceedings. Findings of the court: no doubt, a petition to quash the FIR does not become infructuous on submission of a police report under Section 173(2) of the CRPC, but when a police report has been submitted, particularly when there is no stay on the investigation, the court must apply its mind to the material submitted in support of the police report before taking a call whether the FIR and consequential proceedings should be quashed or not. More so, when the FIR alleges an act which is reflective of a dishonest conduct of the accused. In the instant case, the FIR alleges that the accused took original complainant's truck/trailer on hire for a period starting from 14th July 2014 up to March 31, 2016 at a monthly rent of Rs 33,000, but after payment of first month rent, the rent was not paid despite false assurances. The allegation that rent was not paid by itself in ordinary course would presuppose retention of possession of the vehicle by the accused. In such circumstances, as to what happened to that truck becomes a matter of investigation. If it had been dishonestly disposed of by the accused, it may make out a case of criminal breach of trust. Therefore, there was no justification to quash the FIR at the threshold without looking into the materials collected during the course of the investigation, to peruse the police report and to understand as to what type of investigation was carried out by the police. On July 19, 2024, we required the state to place the charge sheet on record. However, unfortunately, though the state filed its affidavit, the charge sheet was not produced. The affidavit filed by the state only indicates that they were not able to trace out the truck/trailer. In these circumstances, we have no option but to remit the matter to the High Court to decide the quashing petition afresh in accordance with law after considering the materials collected by the investigating agency during the course of the investigation. Accordingly, the appeal is allowed. The impugned order of the High Court is set aside.